These four bills I've been introducing this legislation, some of them for several years now, and I like to say, I think with same thing with the Representative Agello on her bills, and I'd like to think that we've done such a good job in the past that our colleagues understand where we stand on these bills, and they don't feel the need to attend, because again, we've done such a good job of introducing these bills in the past that I think they stand on their own to a certain degree. My approach with these bills is everybody agrees that we overcriminalize, and there's a problem in our society with the school to prison pipeline, and that a lot of the emphasis from my perspective has been on post-prosecution, attempts to assist individuals who have been convicted of crimes and now deserve, sometimes rightfully so, deserve a second shot after they've served their penance to society. Well, I grew up learning about politics, learning an additive. I would rather, and it goes something like this, as a jurist in England, I would rather see 10 guilty men go free than one innocent man be placed into prison. And that's a core tenet to the founding of this country. That quote was attributed to a gentleman in England around the same time that our founding fathers were writing our Constitution. And the bills before us, I believe, are my attempt to set right travesties in our criminal justice system, whereby we have given the prosecution the tools they need. Matter of fact, in my opinion, we've given the prosecution too many tools to the point now where they can over-prosecute an individual to the point where they can't afford to properly defend themselves, so they're forced into a situation where they have to plea bargain. And every time we hear it, the Attorney General says another tool in the toolbox, another tool in the toolbox. And I think we need to start moving the other direction. Starting off with the first piece of legislation, 5359, and I just call this the Bill of Rights Enhancement Act. There have been, there is a there's a Supreme Court decision dealing with what they call the open field doctrine. And that allows that, for some reason, they believe that that the government can place recording devices on your property without a warrant just because it's outside of your curtilage. The curtilage being the area immediately around your house. So police can come on your property and put cameras anywhere they want to, and they can make an argument, say, oh, it's not on the curtilage, without a warrant. And they record everything that you and anybody that you allow to be on your property to do, lawfully or otherwise. And this would state that the right to have the ability to prevent that from happening would require going forward a warrant in the state of Rhode Island. The other one I have on here, they're bundled together, is double jeopardy. Double jeopardy is a cornerstone in our government. Once you are found not guilty on the facts, you should not be prosecuted for a crime a second time. And in our system now, due to the way we interpret the dual sovereigns, if you're found not guilty on the facts in a state or federal court, the other jurisdiction can take that and prosecute you again. If you're found not guilty in another state, your state, on the facts, again, not a technicality, but on the facts, you're found not guilty of a jury of your peers, you can then be prosecuted by another state or another jurisdiction. And this would ask that in the state of Rhode Island, if you're found not guilty in another jurisdiction, whether it be federal or state, on the facts, barring any new evidence presented, that you cannot be prosecuted for that crime. That is 5359. Let's get back into this. 5360. 5360 has to do with these things we have in our hands. Our Constitution protects us from unreasonable searches and seizures of our property, our papers, and a whole series of things. But for some reason, what we produce on these phones, whether it be data or otherwise, if we produce it, if we're being investigated, they don't need a warrant or probable cause to access the data that this device is presented. I own this device. I produce the information on this device, whether by my movements or by me physically saving things onto this device. But currently, in order to get the information that this thing sends out, law enforcement only need a subpoena. There is no protections, no requirement for a warrant and proof that I've actually may have committed something or committed a crime. And I believe that is wrong. And I believe that we need to update our statutes to reflect reality. Our Constitution doesn't recognize this thing as our person, as our property, or our papers. Well, this is my contemporary papers. The things I put in here, my emails, my banking information, all the information, these are my contemporary papers. These are the things that our founding fathers would have had on their desk in their homes. These are their papers. And these should have the same protections as those things do as well. The other piece in here, in the same piece of legislation, is the requirement for law enforcement, if they're going to use a stingray cell tower. What a stingray cell tower is, in essence, it's a device owned by law enforcement that will fake your phone into believing that it is a legitimate cell phone tower. And it will send all that information that you send over your device to that cell phone tower. Now, if anybody who's ever participated in a rally, a political rally at the State House, you will see these things sitting around. We'll have cameras on them and other things. And it doesn't matter if you're a member of the Tea Party, Black Lives Matter, or whatever organization. If you've come up to this State House and protested, they know you've been there. They've taken a list. They know that you have been there. Just because you're trying to, take advantage of your First Amendment rights and tell this government what you think. But now you're on a list. You're on a list as being a BLM, Black Lives Matter supporter, or a Tea Party supporter, or the supporter of the Second Amendment, or whatever it may be. Now, your phone is registered as being on there. And I would say that the only way government should be able to use these devices is, again, with a warrant. They should only be able to collect this information if they have a warrant with probable cause that a person has committed a crime, and that they're actively seeking out and trying to solve a crime. That would be 5360. 5363. Currently, there's a thing out there called civil asset forfeiture. For anybody who is presumed to be involved in illicit activity, specifically around controlled substances, in which law enforcement, if they find large amounts of cash or a vehicle or anything that they believe that was used in criminal activity, they can civically take your property without a conviction. And your ability to get that property back is exceptionally difficult, almost near impossible. So what this would state is, you can no longer take somebody's property, even if just because you think it's related to a crime, until that person has been duly convicted. I think that's a very simple thing to ask of our criminal justice system, that before you take something that you think that was used in a crime, prove the fact that it was a crime. Until then, don't be taking people's property away from them. In some situations, you're talking about people who literally have lost their entire life savings because they were going to make a large cash purchase, and they lost their entire life savings because someone assumed that it was being used for nefarious purposes. And again, I think that's a travesty of justice in a system that, it was founded on that concept. Again, I would rather 10 guilty persons go free than one innocent person be convicted and sent to prison. The final piece of legislation I have on here is 5445. Every year Law Review does an assessment of all the bills that we pass to balance them against any past laws. And they recommend either, minor grammatical changes that have been found, or maybe things that we need to update based off of the laws that we passed this year. This just simply asks that same law review process incorporates the Supreme Court decisions that have been finalized. Not something that may be still under review or that could be appealed to a higher level, but any decision the Supreme Court has made and identify any laws within the state of Rhode Island that may violate that constitutional principle that's been established by the courts. And again, it would just give us the opportunity to potentially take action. And because for those at home, you've got to remember, just because the Supreme Court finds that a bill is unconstitutional, it doesn't mean that a cop can arrest you for it if it's still on the books in Rhode Island. They can still arrest you for it. You still have to go through the process. You'll get charged. You'll have to get an attorney, and you'll have that attorney have to make an argument. And I don't know how much that's going to cost a person, but if we find a law that's been found unconstitutional, we should take that bill off the books so that people aren't being unduly charged for laws that just may not be constitutional or just.